Aloha and good afternoon. One of the realities of life now is the number of disputes that occur in our community. And one of the ways that is now being used as a way of resolving disputes is alternative dispute resolution. And this afternoon, I am honored to have three distinguished attorneys who have experiences in alternative dispute resolution. Maybe each of you can introduce yourself and give a brief resume of your background, especially in the area of alternative dispute resolution. Cindy?
Okay. I'm a real estate attorney, and I started mediating cases around 1996 or so. I was trained by the Mediation Center of the Pacific, and since then I've done a variety of cases, from special education to helping people who have bought and sold products on eBay to resolve disputes that they may have had there.
Nice. Next, Gary.
Yes, I'm Gary Grimmer. I'm an attorney here in Honolulu. I've been practicing for 39 years, and in those 39 years, in civil disputes that are usually in court, the use of mediation or arbitration has become increasingly prevalent to the point where our Hawaii state courts and our federal court have rules mandating us to go to mediation or settlement conferences prior to going to trial. So it's become applicable in all the civil cases I work in. And it's a good development, and we'll talk more about that later in the show.
All right, good. Lisa?
Oh, hi there. I'm Lisa Jacobs, and I'm a mediator and I'm a collaborative attorney. I've been practicing here on Oahu for 21 years, and my specialty is helping families go through a divorce or separation, but do it in a way where we can work out settlements in a more collaborative way and avoid litigation.
Lisa, before we go on, because I myself was not familiar with collaborative, what is it called?
Collaborative law or collaborative
yes.
divorce.
Maybe at this point we should tell the viewing public what it is so that we have an understanding of the concept.
Okay. Sure. Collaborative law was developed about 25 years ago on the mainland. There was a family law attorney, and his name was Stu Webb. And he had been practicing divorce and family law for many years, and was trying to think of a more constructive, respectful way to resolve disputes. The reality is that most divorce cases do end up settling, but the idea is that with an adversarial system, where the parties are played against one another, it really is not, again, the most efficient and constructive way to resolve things. So a process was developed where the family law attorneys and their parties will all enter into a participation agreement early on in the process, where they're going to pledge that they're going to work their hardest to arrive at settlement. And there's a disincentive for the attorneys to litigate or to threaten to litigate, because the participation agreement includes a provision where the attorneys are disqualified from representing the parties in litigation. So it really is self-selecting in that the parties and their lawyers are really really motivated to try to come up with something that's going to work best for everyone. And the Uniform Collaborative Law Act was an act that was passed in 2009 and has been adopted by, I think, about 13 states now, including the state of Hawaii, which adopted it in 2012. And it codified this collaborative process to provide both the general public and professionals who practice collaborative law with procedures and expectations. So we can proceed in that way in a much more standardized manner, and it's helpful for both professionals and for the general public.
Before we go on, maybe I should ask you, and maybe very briefly, what would be the difference between collaborative law and alternative dispute resolution, conceptually, very briefly?
Conceptually, I think that collaborative law is a subset of the many different ways that parties can resolve disputes in different ways as an alternative to litigation. So I'd say it's a subset, and there are some similarities between collaborative law and mediation. And that's why I actually, as a professional doing both, in one case I only play the role as a mediator or as a collaborative lawyer, but I feel like they are similar enough that what I put myself out as is a professional that does not engage in litigation in any means, but I can help parties either as a mediator or as a collaborative lawyer resolve their disputes.
At this juncture, maybe, and I'll throw it open to everyone here, what is, because many of the viewing public may not be aware of the concept of what is alternative dispute resolution. So maybe Cindy, you can give us your take, and all of you can give
Ladies
us.
first.
What is it, you know?
Well, it refers to alternative to court, so an alternative to litigation, and that's how we got the acronym ADR, Alternative Dispute Resolution.
Let me stop you right there. What is the benefit of alternative dispute resolution as opposed to going straight to court?
The thought is that you could have resolution faster and maybe more cost effectively. And in some of cases, for example, in mediation, you can retain some of the relationship that the parties may have had. If you go to court, oftentimes, if parties have a relationship, that relationship is not strengthened, but it's it's torn apart because of the way that litigation is conducted. So if you have a process where parties may still be able to resolve their disagreement but retain their relationship, that's one of the benefits for using alternative dispute resolution.
I'm going to ask Gary a question. In your practice, and without giving any confidentiality away or privileged communication away, in your practice, do you start with mediation first, or do you go straight to arbitration? Or if you fail on mediation, is it your practice to go to arbitration then?
Yeah.
Generally, what is your practice?
Well, increasingly, we are trying to mediate first. And mediation can actually
Can
be...
I ask you why?
Yes. Because if you have a lawsuit, if you have a right to sue somebody, once you get in the court system, they are going to force you under the court rules to go to mediation anyway. Sometimes it's called a settlement conference, but they're going to force you to go to mediation anyway. So an experienced lawyer will tell their clients nowadays, we're going to be forced to mediation eventually anyway by the court system, so why don't we see if the other side will engage in good faith, fair mediation with us early on, save everybody time, save everybody money. And I agree with Cindy that it helps preserve any business relationships or familial relationships those people have if they can succeed in mediation. And just let me give one very quick example how this is such a commonplace thing nowadays. The purchase contract that the Hawaii Board of Realtors issues, that almost every Hawaii realtor uses in the sale of a personal residence, has a required mediation clause in it. So a lot of the disputes that come to me are disputes about contracts that already require them to go to mediation. So increasingly and overwhelmingly, you start with mediation.
Gary, in the case of the Honolulu Board of Realtors or Realtors, is the mediator a real estate broker, or could it be someone other than a real estate broker?
Well, in their purchase contract form, it can be any mediator the parties agree to. So it doesn't have to be a realtor, it doesn't have to be a lawyer.
I see. But wouldn't it be to the advantage of the disputing parties to have someone who's familiar with the subject and therefore a broker?
Yes, it would. Yes, I agree with that. In fact, my earliest experience with alternate dispute resolution was in the construction industry. They were the first industry to really put in their contracts, you have to arbitrate. You cannot have a lawsuit, you have to arbitrate. And those arbitrations, always in the beginning of that procedure years and years ago, were experienced construction people.
I see. I'm going to open it to all of you here. Based on my experience, and say we go beyond the mediation level and you go to arbitration. Cindy has just mentioned that it's more cost effective to go to either mediation or arbitration. Now, I'm going to focus on arbitration. From my experience, I have found that if we were to go to arbitration, the lawyers on both sides seem to spend as much time doing the work in preparation for the arbitration as we would do litigation. The only difference is, and I think I say this kiddingly, is we can choose the decision maker in an arbitration. In the court system, it's the judge who decides, and we don't have the right to choose a judge. So I'd like your take on, maybe all of you. What is your thought about this cost effectiveness advantage? In reality, is it really cost effective? Lisa.
Well, that's a good question. And you're focused in on arbitration?
Arbitration.
Okay, because I don't do arbitration. I'm not an arbitrator.
All right.
So it's probably more appropriate to ask
Well,
perhaps.
let me ask you,
Okay.
to prepare for even mediation, you need to prep. Yeah.
Correct.
And so don't you prepare for your mediation as much as you would do if you were to go to litigation? Because you want to be able to cover all of the points that would be covered in a litigation. And you write memos, or you write whatever opinions that the mediator might want to ask. Or do mediators ask for memorandums? I don't know. Do they?
Well, there aren't specific rules. I mean, with litigation, there are prescribed rules on how one conducts themselves as a litigation attorney. In mediation, things are a lot more flexible, so it really depends on the style of them, what the mediator is asking the parties and for the attorneys to produce and to provide. So it's more flexible, so I suppose that there's some benefits to that, but there can also potentially be some drawbacks to that, because it really depends on the mediator and how that mediator is conducting his or her mediation, because the mediator is in charge of the process.
Oh, right.
Yeah.
What is your take, Gary?
Well, first of all, I don't think Cindy said that arbitration is less expensive than litigation.
Oh, excuse me.
Because they're very similar.
Yeah.
But I think she did say that mediation gives the parties a chance to resolve their differences for less expenses than if they started with arbitration or litigation. There's no question about it. Well, let me say two things about the cost effectiveness or the difference in costs.
Mm-hmm.
The Hawaii Arbitration Act does give the arbitrator the authority to limit certain things that would normally go on in a court trial or a court lawsuit. For example, the arbitrator can limit how much discovery the parties do ahead of time. So that
Right.
would save money.
Right.
And even though there's a benefit to picking the arbitrator, the parties jointly pick the arbitrator out of respect, and hopefully that will help the situation get resolved more fairly and more to their satisfaction, you have to pay that arbitrator.
Right.
So unlike court, where you don't pay the judge, the taxpayers are paying the judge, an arbitrator gets paid by the litigants. But they also get something very important in some cases, and that is it's confidential. Whatever goes on in the courtroom's open to anybody to walk in and watch in the courtroom and read any of the pleadings that get filed in there.
Mhm.
Arbitration's a closed proceeding, and so if parties want confidentiality in their dispute, that's a benefit to arbitration. There are many arbitration cases that are not less expensive than if you went to trial. And that's unfortunate, because part of the benefit of alternative general dispute resolution in general is to save people money in getting their dispute resolved.
All right. Excuse me. This is our first break already. So we are going to take a short break. If anyone has any question, please contact us at Think Tech Hawaii. Thank you.
Hi, my name's Cindy Matsuki, and I host the show High Growth with HTDC on Think Tech Hawaii. This is the show where we talk about all things tech, innovation, entrepreneurship, and manufacturing, because there's so many things going on in Hawaii and more people should know about them. So this is the program that you can come and find out about all the things happening in Hawaii. And this show also airs on Olelo 54 along with Think Tech Hawaii. And it broadcasts live every other Tuesday at 3 p.m. So don't forget, check out the show Tuesday, 3 p.m. every other week. High Growth with HTDC. Thanks.
Hi, I'm your host on Think Tech Asia, Bill Sharp. I look forward to you joining us each Monday between 4 and 5 o'clock when we film right here in our studio in downtown Honolulu. The show, Think Tech Asia, focuses on contemporary events in Asia. And by Asia, we mean anything from Hawaii, south to Australia and New Zealand, west to Pakistan, and as far north as the Russian Far East. Clearly, this is one of the most economically dynamic centers of the world, and we bring you up to date on what's going on in a whole host of countries in this very vital region. We look forward to seeing you. Aloha.
Good afternoon, and we are back again. This afternoon's topic is alternative dispute resolution. Before we go on, maybe Cindy, you can explain to us, because within, I think it's all 4 circuits that they now have a, is it a mediation or arbitration?
Arbitration, court, non-binding arbitration.
Non-binding arbitration. Would you explain to the viewing public, Cindy, what is this non-binding arbitration within the court system?
I think probably Gary's better suited to answering.
Okay, I'll try to do it as briefly as I can. I don't want to dominate here, but it's called the court annexed arbitration procedure.
Yeah.
And certain types of cases.
Excuse me, Gary. Who are these arbitrators?
Attorneys.
And how are they appointed?
You volunteer to be on the panel that the arbitration judge in each county or each island selects from, and you do it on a volunteer basis. You can get a $100 honorarium if you really insist, but everybody just waves at and does it for free.
I didn't even know they were paid.
Yeah, well, hardly anybody asks for it anymore.
Right.
So, and what it is for cases, it's for the smaller cases that are in the circuit court. So, example, somebody gets injured in a vehicle accident, and their medical bills are $20,000. Their pain and suffering was relatively brief. So their cases, in the legal parlance, their case is worth less than $150,000. So the court system makes you go to a non-binding arbitration. It's usually a day or less. The attorneys don't have to prepare as deeply as you do for trial. They present almost all the evidence on paper. There might be only 2 witnesses in the whole proceeding. And then that arbitrator issues an advisory award. And that award says, if you went to trial, we think the result would be this, and the amount of money that would be awarded is this. And then the parties can accept that as the final decision, and the judge will enter that as the final decision. Or they can choose to go to a trial in court, ignore that, and go to a trial in court.
You start fresh.
Right, but if you don't do better than if you go to the court and you don't do better than that advisory arbitration award, you got to pay some of the costs and expenses to the other side.
Oh, that's the risk.
So there's a catch.
Mm-hmm.
There's a catch to going to court and having a trial.
Cindy, I want to ask you, and you correct me if I am wrong, but weren't you also involved in some neighborhood dispute resolution at one time or the other?
Okay, so the Mediation Center of the Pacific
that's,
originally was called Makiki Neighborhood Justice Center. And they started about 35 years ago with the idea that people themselves could resolve disputes on their own. And these were primarily neighbor type disputes that they started with.
How how would this, the two disputing parties find this organization?
So
And did it have to be in Makiki?
it started, I think, as part of the Makiki Neighborhood Board.
Oh.
And so I think that's how the Makiki location was determined.
Yeah.
Mediation Center of the Pacific is a community mediation center. There are others that are located on other islands as well. And so they provide affordable and accessible mediation services for the community. And this could include providing mediators for district court small claims cases.
I see. Do they have to be attorneys again?
There are a range of people who are
I see.
trained in mediation techniques, so that you do not have to be an attorney.
When you say techniques, that always raises a question in my mind. Do you have seminars or schools or whatever you go to learn about these alternative dispute resolution methods? I mean, do you just, how do you learn about these?
There are organizations that provide training
Here in Hawaii?
here in Hawaii and also on the mainland. And now many of the law schools have courses on conflict resolution, which would include negotiation and mediation. So it's much different in terms of law school education that was available, I think, when
Please
we-
be careful now.
when we attended law school.
I am very age sensitive.
My daughter is thinking about law school, and she said, you know, I can do a concentration in conflict resolution.
Oh, it's an elective.
Yeah, it's a focus area
I
on
see,
some of
I
the
see.
law school programs now.
All right. Lisa, let me ask you again, based on my limited experience in handling domestic relations matters, and I commend any attorney who does these domestic relations cases, because it's not only emotionally exhausting and distressful for the two parties, but it's also very stressful for the attorneys who do this kind of work. Now, my specific question is, when you have a client, do you from the beginning sort of advise the client that there are these other processes besides going to court to resolve the problems? And I'll tell you why. Because many of these domestic relations cases, divorces, I'm going to speak for myself now. I did not charge, I charged a fee, but when I read some of these experiences, some of these lawyers, they are charging hundreds of thousands of dollars to resolve these cases. So I'm thinking maybe I should, it's an area that's it seems quite lucrative for a young attorney. And so how do you tell your clients from the onset that there are these alternative resolutions available, and how do they react to them?
Yes. As a matter of course, I always give prospective clients all of the different processes in which they can resolve their family law issues, anywhere from a kitchen table negotiation where they don't hire any lawyers and they can assess the Hawaii State Judiciary website to get the uncontested divorce forms. They can do it as easy as that and only pay the filing fee and a Kids First fee to resolve their divorce. Or they can go the other end of the spectrum, which is litigation. That litigation is what I don't happen to do at all. So if they're interested in doing litigation, I have to refer them out to a colleague of mine. But then there are the other methods that fall in between that range. And those methods that fall in between those range include.
What would, yeah, I'm sorry.
Okay, that includes mediation
Mhm.
and also includes collaborative law, and those are two areas I deal with. Also, attorney-assisted negotiations could be.
Say that again?
Attorney-assisted negotiations, which is, parties hiring lawyers to help resolve their case.
Oh, the lawyers are paid.
Yes,
Mhm.
yes, they're hired to help negotiate a settlement for the parties.
Mhm.
So that's another option. Private judging is another option. That's almost like a private judge is almost like an arbitrator who will make a decision on any issues that the parties don't already agree to.
Is it advisory or binding?
It could either be binding or it could be advisory, depending
I see.
on what the parties decide to do. So, and you can have a combination. You can have a mediation arbitration. If the parties can't resolve issues in mediation, I don't feel comfortable playing a dual role as a mediator or an arbitrator, but I could refer any issues that are unresolved in mediation to a separate arbitrator or a private judge to help resolve any unresolved issues that the parties can't come up with on their own. So there's a bunch of different ways you can assist parties in resolving, and whether or not we charge, I charge a fee either as a mediator or as a collaborative attorney. Again, I can only fit one role. I can't play dual roles.
Right. And you advise and maybe apprise the clients from the very beginning.
Yes, and I'll let them know what the benefits and drawbacks are on each method. Generally, the people who get referred to me are generally those people, they're referred by therapists or by counselors, people who really want their dispute to be resolved more quickly and cost effectively. And usually they want to try to preserve an ongoing relationship, oftentimes because they share children together. So that's why the focus tends to be more on mediation, collaborative law. That's the reason why they're coming to me. But I also let them know about about the litigation option as well.
For the sake of time, and we should talk about this because we're lawyers, what is the statutory basis, if any, for alternative dispute resolution? Are there statutes governing alternative dispute resolutions, Gary?
Well, there's more than one statute that might come into play, but the basic one that I deal with a lot is the Hawaii Arbitration Act, which is Hawaii Revised Statutes 658, capital A, and it sets forth procedures and rules and authority for the arbitrator, and it also sets forth the rules on how an arbitration award can be enforced through the court system if the losing party doesn't comply with the arbitration award. So you can then take it to
enforce
it through the courts.
I see.
The arbitration system doesn't enforce the what's called the arbitration award, but that statute does provide how you go to court and get it enforced.
We have to take another break.
Okay.
All right. So we will take another short break and we'll be back in 1 minute. Thank you very much.
Hi, I'm Donna Blanchard. I'm the host of Center Stage here on Think Tech Hawaii. Center Stage airs every Wednesday at 2 o'clock, and of course you can check out our archives on YouTube or on Think Tech Hawaii anytime you like. Why should you do that? Because this is an arts show that I believe is making a difference in lives. We talk with artists of various ilk. We talk with painters and writers, playwrights, novelists, poets, sculptors, dancers, you name it, directors, actors, of course. And we don't only talk about what people do, but we talk about how they do it. And my favorite part of the conversation, we talk about why they do it. And it's really common on this show to hear people say, wow, I didn't think about it that way. And it's very common to hear people afterwards who have seen the show say the same thing. And I hear all the time that people are inspired by the conversations that we have. So why don't you join us and be inspired too? That's Center Stage on Wednesdays at 2 o'clock. We'll see you Center Stage.
This is Alice Lee Hagan, host of Think Tech Hawaii Business Education Spotlight. My show here at Think Tech Hawaii is every Thursday from 3 to 4 in the afternoon. I bring in interesting guests from Hawaii, the mainland, and hopefully international guests in the future. Do join us on Thursday from 3 to 4 p.m. ThinkTech Hawaii Business Education Spotlight. Aloha.
Portray the selection process.
If you want to talk about cases, I think the consumer arbitration might be in.
Okay.
Yeah, let's talk about that.
Aloha, and we are back again on alternative dispute resolution. We have 3 outstanding attorneys in this area of the law. And before we went on our break, we were talking about statutes, and Gary explained the statute on arbitration. And I understand there is also a statute on mediation. So Cindy, if you can explain.
There is a Uniform Mediation Act which was passed by Hawaii, and it, although the title says Uniform Mediation Act, it really primarily focuses on confidentiality and privilege in terms of the communications during a mediation.
Does it explain about the mediation process? And the selection of mediators?
Just a voluntary process that the parties engage in. So there is a sense of wanting to keep the mediation process very open and flexible, and so that it can be applied to different situations effectively.
2 different situations, meaning?
Well, you can have mediation relating to commercial or business disputes, litigated cases. Some mediations, like the eBay cases, occur without a court. And one of the reasons that they started to do mediation process is because it was outside of the court system. You'd have buyer, for example, in the United States, and a seller maybe in England. And so which laws apply?
Right.
And
it's a jurisdiction problem.
And they're geographically separated. So it was a way to help the parties resolve their cases, and then also to have confidence in the transactions.
Cindy, you know, for the viewing public, I think that's a very practical process. Let me ask you, if you have one of these issues or disputes, how does one start the process if one is in England and one is in Paris? And
Okay, for that process, and I'm not sure that they still have it. I'm no longer doing mediations for the eBay cases. But
excuse me, but as we know, I don't know about all of you, but I purchase a lot of things through online now.
Right.
And so, you know, it's a real issue, I guess. So I think that's a very useful thing for the public to know.
It is a way for people who have online transactions to resolve the disagreement or problem without having to go to the legal system.
I see. Well, again, for the sake of time, maybe all 3 of you can tell us if there are any Hawaii cases pertaining to alternative dispute resolution that you are aware of. Cindy?
Yeah, I just looked briefly at the legal case research software, and there aren't too many cases relating to mediation that we would probably be interested in talking. And there are a number of cases relating to arbitration.
You know, the most of the court cases that had to deal with the arbitration process dealt with whether or not the parties had to go to arbitration. Sometimes one party or another does not want to go to arbitration, but they've had a contract that purportedly says they have to. So there's a few cases out there about whether they have to go to arbitration or not. There's some cases out there about whether there was adequate disclosure from the arbitrator about his neutrality in the situation. And then there's quite a few cases enforcing arbitration awards. I would have to summarize all of that by saying it's probably much more interesting to the attorneys that practice law than it is to the people that might consider arbitration. And, you know, so I think it's much more of an attorney interest in the cases than it would be to the public that might want to use the process.
But for the public who is involved in this dispute, like many other situations, you know, the losing party is upset most of the times, and the losing party will ask the attorney, what is my option having lost this case at this stage?
Mm-hmm.
And so, although attorneys might be interested, on the realistic level, I think many times the clients are also very interested in knowing what the options are, I would think.
Well, it's very important if you're an attorney that's going to recommend arbitration to your client, or if your client has to go to arbitration because they agreed to it previous to coming to you, it's very important to tell them how binding an arbitration award is and how narrow their remedies are thereafter. There's very, very little you can do to upset an arbitration award by going to court.
Could you
later.
tell what the appeal points might be, or reasons might be?
Can I tell now, you mean, or
Yeah,
when I tell the client?
No, now.
Oh.
So
Well,
that the client,
yeah.
so the public may.
Yeah,
be
well,
aware.
the only way to upset an arbitration award, the only way a court can upset it is basically to show either some lack of impartiality or neutrality in the arbitrator himself, or some fraud to the whole arbitration
fraud.
process by one of the parties.
But that's very rare. isn't
Oh,
it?
these things are very rare and very hard to prove.
Right.
So if you're going to arbitration, you better be ready to live with the result.
Lisa, again, this collaborative practice, which is relatively new to me, it seems from what you tell me this afternoon, it's becoming more and more a prevalent practice. Am I correct?
It's slowly growing throughout the United States and actually throughout other countries around the world. And in Hawaii, it's relatively new. The law was passed in 2012, so it's just about three and a half years old. So it's slowly gaining momentum.
Yes. Is this applicable for other than marital relations cases?
Yes, it could be applicable in just about any type of civil dispute where the parties want a cost-effective, quicker, private way that they can help control the outcome. And yes, so it can be used in any, theoretically, trust and estate disputes, family business disputes, partnership dissolutions. I can think of a bunch of examples. I'm not aware of many cases other than family law cases in Hawaii where collaborative practice has been used, though. Yeah, still relatively new.
Let me go back again to cost, because this is a very important point for the
Sure.
clients, cost. What is the difference, if any, again, in the cost of alternative dispute resolution versus this collaborative practice?
Well, collaborative practice is very interesting because it can be as simple as two collaborative attorneys working with their clients to help resolve a dispute, and they're engaged in negotiations and trying to resolve it as quickly as possible. What makes collaborative practice actually very flexible and interesting is professionals realize that especially divorce is not just a legal issue, it really is an emotional issue,
Right.
and there's financial consequences as well. So in addition to having lawyers who are collaboratively trained to help the parties work through their disputes in a more constructive, respectful way, there's also mental health professionals and financial professionals that are trained in collaborative practice also, and they the parties can hire those professionals as well. That does add additional costs.
In what way?
Because the financial professional and the mental health professionals are also charging fees. So I wouldn't say if you have a full collaborative team working with a couple that it's going to be necessarily cheaper because there are these additional professionals involved. However, you can get a more integrative and richer and more sustainable, resolution to the matter. So for every dollar to dollar spent, if you compare it to a full-blown litigation case where a lot of experts are hired and the whole thing is very, very adversarial, you're likely to still have a lower cost, and the outcome is going to be more sustainable, and hopefully you've preserved some relationship or you've helped in helping to heal some of those relationships.
One question, Gary, again, a practical question. What is your take on, say, mediation? Do you find that if you have for the lack of a term, I say, an experienced mediator, the chances of resolving a dispute, and I refer especially to family-type disputes, if you have the right mediator, have you found that the mediator is able to resolve these family feuds in a more harmonious way than if you had someone who wants it right or wrong? Absolutely, I want my case handled this way.
Well, the way I like to say it is it takes two to tango to have a good mediation. So if there's one side that's just obstinate and doesn't really want to be there or doesn't want to participate in good faith, you're not going to get something resolved. So the first thing you need is two parties that are willing to really give this a shot and really try to work it out. When you have a mediator helping, the biggest thing they do, and this is what experienced mediators know how to do, they shuttle between both sides. And an experienced mediator can tell each side in a way that's more acceptable and palatable to them why it's in their best interest to make this concession or to make this change and to try to reach an agreement, as compared to hearing it directly from the spouse or the adversary, whichever kind of mediation you have. An experienced mediator can really help deliver those communications between them in a way that's much more likely to bring them together in a resolution.
Cindy, let me ask you this. Do you think in the future we will have more of these neighborhood type resolutions as opposed to disputing parties going to court and trying to resolve it in court? I would like to take as an example. I don't know why, for some reason, I've had several cases involving trees. Yeah. And you have a neighbor who's upset at his, neighbor across on the other side of the boundary because the mango tree is overhanging his boundary. And I've even had one case where I took it to court. But what is your take about, trying to resolve these neighborhood type disputes amicably by this neighborhood type process?
Of course, because we're in alternative dispute resolution, we would like to see more people use a process that would allow them to talk through the problem rather than to fight it out.
Especially since they might be neighbors.
Right,
Yeah.
and they would have an ongoing relationship. It really does make a difference to whether or not parties are motivated to try to work through a solution. But what I found in doing mediations is that oftentimes if the two parties are having emotional dispute and both sides have high emotion, those are the cases that are probably the easiest to resolve.
Oh, is that right?
Because there's something going on between the two parties. And so the mediator can figure out what that is, and to find a solution that works for both, it works. The ones that are harder to resolve is where one person is really angry and the other person says, "Oh, I don't care about that." Those are much harder to get the
Excuse me
"I
for
don't
laughing.
care" person
it's not a laughing
to want to
matter.
resolve it. I think those are more difficult. And so when I first started, when we had cases that were high emotion, it was a little daunting. But I've come to realize that those are really much more satisfying and somewhat easier to work with.
I have learned quite a bit this afternoon. In fact, and so I would like to thank all of you for being my guests, and maybe in the future we can continue this discussion, because this is a very not only interesting, informative interview, but I think it's on a practical basis very helpful for parties who have a dispute. So thank you very much for coming this afternoon.
You're welcome.
Thank you.
Thank you.
Thank you.